Court officer. Court officer.
ಸರ್ ಹೇಳಿ ಸರ್ ಹೇಳಿ
Pradeep Kumar. The circumstances do not find any merit in this petition and accordingly. Yeah. The applicant submits that the office objections have been. Is the IS can be allowed, right? One, yes, two, and and same 1 of 21, 2 of 21, 3 of 21 allowed. All 6 applications allowed. And then submits that office objection has been complied with. Let the appeal. What whose name is to be deleted here? The office is directed to delete the name of Mr. G.R. Anantram as the correspondence. It's 9A to C and 10. Let the appeal be listed for order on admission in. You file amended cost that will be filed within a 1 hour. Yes. Compliance of IA for dispensation. Dispensation. What? Requirement of service of notice on so on respondents as sought for in the memo is dispensed with the effect of dispensation that considered at the time of hearing of the appeal. 4 and 6. Three orders are required to be passed. 4 and 6, right? No. What is that serial number 4? Then 7 also does not survive, right? Because IA 1 of 2020. No. Serial number 4 based on IA 1 of 20. No. You said no, it does not survive. Then 7 also no orders are required to be passed. 8 and 9. Yes. What about 1 and 2, Mister? What about 1 and 2? Huh? Yes, Mister. Office respondents. They have to comply, right? 2 weeks time. All right. 2 weeks time to comply. Then dispensation. Dispensation is allowed, right? Requirement of the copy production of annexures is dispensed with. Result IA 3 of 19 is allowed. Huh?
Serial number
3.3. Oh, yes. 3.3 also dispensation, right? Let the appeal be listed for orders of admission thereafter. Admitted. Oh, appeals have been admitted, and then right, appeals have been admitted for hearing. Let the same be listed for final hearing on 13th October. IA 1
for 20 to early hearing, therefore.
So then IA 1 of 2020 does not survive for consideration. On IA so and so, taking into account that appeal is pending since 2019, same is directed to be listed on whatever date. Intent. IA therefore 1 of. What are these appeals? You said that they are not entitled for regularization. Give us short synopsis of facts. There's nothing we decide by whatever. Please prepare a synopsis. There's nothing. These appeals, a short issue. We would have prepared a synopsis today, we would have decided. We write facts and all that, we will take half an hour to narrate. Please prepare a synopsis, short facts, what happened. We have listed for final hearing now. What office? Relieving order. So, office 3.7, office objection has been, like with the same is therefore ignored. List for final hearing. Intent, right?
Hello, क्या कोई sound check रहे हैं?
Yes. Second time. Each time, failing which appeal shall stand dismissed for the respondent number. The session is right. Allowed. The requirement of filing. Dated copies of annexed IA 1 of 22 is allowed. IA 2 of 21 shall be considered at the time of hearing of the hearing. Yes. Learned counsel for the appellant submits that the appellant has taken steps 3 times for service of 7 and 8. Respondent has not been served. If grace warrant is granted to an application. Service on of the respondent's back. If any shall continue.
Six, therapy.
Right. What we call, what is the office objection, Mr. Recall? So what is the office objection on that application? Third on IS dated so and so 2020 reasons aside that he called so and so is restored to file less office objections be complied within 2 weeks. Accordingly, IA 1 of 22 is allowed.
Number 8, starting person, Srinivas Murthy.
7. What happened to 7? Weeks time. Preemptory. Comply with officer.
Srinivas Murthy. Number 9, Venkatesh here.
What 7 office objection, right? Fine.
Number 9, Venkatesh here.
Today I'm not complying.
Yes.
Number 10,
Withdraw. What is it? I'll remember taking leave. Oh, it has it been entertained? No. Well, second set file money. If it does not survive, what happened? Appeal under 49. The additional government advocate points out that against an order dated 9/7/2021, the appellant have an alternative efficacious remedy of filing an appeal under section 49C of Karnataka Land Revenue Act. In view of aforesaid submission, we are not inclined to entertain this petition, even otherwise The petitioner has filed a memo seeking leave of this court to withdraw the late petition. Therefore, the petition is dismissed as withdrawn with liberty.
Your Lordship, appearing for the petitioner in this matter, we may be permitted to withdraw the matter, Your Lordship.
Settled, madam. Respondents have taken care of your grievance. Negotiation took place.
We are trying to do it, Your Lordship.
Yeah.
PIL, madam.
PIL, no. Conduct an inquiry to a genuine beneficiary. What is SDRF scheme, madam? The party.
There is a party. The state is a party here. Nobody else.
Seeks leave of the court to withdraw the petition. It is dismissed as withdrawn.
Grateful, Your Lordship.
Why you want to withdraw? Why?
Your Lordship,
Why do you want to withdraw the petition?
Your Lordship, the matter is not going any further, so we have got instructions not to contest the matter.
Instruction? Your senior told you so, right?
Yes, Your Lordship.
What is it? Why are you withdrawing?
We do not wish to contest the
you
matter
don't-
any further, Your Lordship.
At the outset, they want to let you see. Withdrawn, it is made clear that is all right, withdrawn. Good thing. Awesome. Yes.
You gave item.
Each time failing which appeal shall stand dismissed without reference to bench.
Lordship, in this matter, serial number 14 and 16, the learned single judge has passed the interim order directing the petitioner not to precipitate the matter in the contempt court, Lordship, till the joint inquiry is conducted.
Oh, which is the order?
Lordship, it was passed on 8th, Lordship, it is not yet released.
8th.
In the 24401 of 2021, Lordship. Writ petition number.
Order in view of order dated 8/9/2022, passed in WP number 24401 part 2021. Hearing of the petition is signed. Parties are granted the liberty to mention the matter as and when the said petition is decided by the learned single judge. 14 and 16.
16 also, Lordship.
Yes, yes.
Thank you. Obliged, Lordship.
Lord, serial number 15, I appear, my lord, for the complaint. My lord, another status report is filed. My lord, where partial compliance, my lord, is yet again reported.
Partial compliance or compliant.
There was a direction, to appoint the principal secretary or any senior officials to look into the irregularities. And thereafter, legal action to be taken, and also to intimate the petitioner regarding the status. Stated the status report in file number 7 of my status report, where 106 cases totally were registered. In 103 cases, appeals were preferred to cancel the grants. In 35 cases, notice has been issued and remanded to the Tahsildar for fresh consideration. 32 cases, they are closed as their legal.
What is it about?
Illegal grants, 13%. With respect to all.
Proceedings are still pending.
No, with respect to only 103, in the 103 cases, only 35 cases are pending. Notice is issued. 30. They are grants. In remaining 36 cases, the RTC is already cancelled and the land is restored to the name of the government.
Yes, Mr.
Yes, my lord. Now, in the status report that have been filed, my lord, they have identified totally, my lord, 106 cases of illegal grants, out of which they say in another 3 cases, the decisions are yet to be taken. Even the proposals are not yet submitted. If they do it, my lord, the matter could be closed.
Out of 135, my lord, a notice is issued. My lord.
Huh.
And remain.
What about 3? He says.
This paper are verified, my lord. The records are old. Should find a status report in another 15 days time, my lord.
Additional government advocate for submits that that the respondent has examined. Who has examined?
It was the assistant commissioner.
Assistant commissioner has examined 106 cases of grant, out of which 35
cases notice has
that
been
35 cases have been found to be cases of illegal grant, and notices have been issued
issued.
by Tehsildar.
Yes.
Where it is also pointed out in 36 cases. What have you done?
RTC is cancelled and land is
RTC has been cancelled and land has been restored in the name of the government.
Yes.
Chief further learned additional government advocate prays for this country for 2 weeks further time to
further status.
to further to enable by further status report with regard to 5 pending cases, remaining 3 cases which have not been examined.
Great.
Right? You have supplied a copy. Applied a copy to them. Hey, we are passing it over. You supply a copy. We'll pass it over. Oh, you serve by email. Praise. And you have not filed it. Learned respondent prays for adjournment to enable him to file the compliance report within 1 week. List thereafter.
You file it in the registry, serve a copy and file it in the registry. Once we have granted you a week's time.
Week's time.
Ready?
Yes, what happened? The order, Mr. What's the order? Okay. What? So grievances only with regard to this visitation right here. Where is the director? No objection to the give entitled for. Yes. During Saturday, Sunday. What's in a month? Then what? Then why he has filed the contempt petition? Right. What night? Who will fix? So Saturday fix. Will fix a time, right? What time will you do? Fine. Fine. All right. Also, yes. Yes. Only timing is, we agreed about timing. 11:30 and by Saturday. 15 September, right? 11:30.
School file.
Acha, school. He's going to Sunday 11:30. That's it. Shall we close it or you want? All right. Then council respondent submits that. Which location? Learn it. What is he? The child is a son or a daughter. Learn it council for respondent submits that. No grievance in this. Grievance in this contempt petition is with regard to visitation rights granted to the petitioner under the in view of the memorandum of agreement arrived at between the parties. Paragraph. Learned counsel for respondent submits that she has no objection to in according visitation rights to the petitioner. Paragraph. In view of officer's submission, learned senior counsel for the petitioner submits that the petitioner shall visit Makeri with prior in Bangalore. Shall visit to meet the child with prior intimation or at 11:30. 11:30 on 18th of September 2020. Right? What right? Yes, sir. It states that so and so. Delete prior intimation. With prior intimation, you say, however, for the purposes of meeting the child on 18/9/2022, she undertakes respondent to ensure that the daughter meets the petitioner at 11:30 on 18/9/2022.
At your residence, where is the venue?
Venue at mediation center. Mediation center is Sunday. Shopping mall. Which? Yes, Orion. Rajaji. Let the petition be listed for further orders on 26 September. Appearing.
Yeah.
19. Yes, what is
Trying to find my reply.
Yes. Consider. Yes, madam. The additional government advocate submits that in compliance of the directions contained in the order dated 3/8/2020, an order has already been passed. She, however, prays for and is granted a week's time to enable her to file a compliance. Which case? This is 19.
Again.
Adjourned. Your case is adjourned for
1 week.
week's time. You were in Harvard, right? The council said, we don't know. Said that he is trying to search to you are at Harvard. That's what he said. He is looking to serve you, looking for you to serve a copy. Office obligation. This one is week's time to enable him to come. Yes. Yes. I find my compliance affidavit. So the direction. Inspection conduct. My admitted in that we receive the notice. Not considered representation. Order passed. When have you passed it?
I'm sorry, 11/7/2022, page 10. Subsequently, we take appropriate to remove the
How many days this application ought to have been considered? 6 weeks. That is the explanation for the delay.
You furnish an explanation. Huh?
all the notice that we issued. Now, but subsequently, after the final notification, confirmation order is issued. Now we have to take action of default. Now, in accordance with the new action, there are 3 pages that is on which date the commissioner has passed an order. Chief commissioner. Okay. Not issued. It is the assistant director of town planning who has to take action.
There's no this thing. Why have you not complied within 6 weeks? No. 6 weeks you have to pass an appropriate order. Explain the delay in compliance. Party in person. They are taking action. They we should notices. Right? What is?
Direction is only to consider your representation. There is no direction to demolish. You might have requested. There is only the direction is to consider it. If you are agreed by the orders passed by them, you have to question it.
We have taken initiative action. Logically, action is to be initiated.
What is the order which you have passed? What have you said there?
To remove the structure. Kindly see, madam, page 7 of my affidavit. There is a 46% human response.
Yes, that's it. They are taking action. There's no direction. They are take action. They are taking action. They got how long we don't know. This is contempt, and what is essential is willful disobedience. Are you in a position to say that they are flouting the order? They are complying with it. They have taken steps. Now you want that it should be in contempt. We should oversee the removal of temple. It should be not. They don't take action. Anything else? So
What time you can, like, because in the notice which you have issued in the month of June, 1 minute, month of June, you have issued a notice to them and said within 3 days they have to. Now it is 3 months.
Still not done. Final notification, confirmation order. Because there was, I requested them to have a meeting with everybody because all that he is requesting, they should not hit the well every day. That they have agreed. And there's one more issue is that there is a common fund from all the apartment owners. You can't pay the priest with that money. That also. Party puts once they into the remote ballot, then we have to go by the act. All we are doing.
no, so within how much time you have issued notice in June? How much time will you take action? That's it.
There is a small idea which is there. Once that is removed, ballot, it will be fully compliant. Not sure kindly get us 2 weeks time. Party person is not objecting for.
Within 2 weeks.
No, this is something different. Your grievance appears to be something different than the direction. That is right. And it's not that. Not the- Fine. That we will decide. We have heard you. Or we'll decide.
Next year. Number 22. The SV Desai.
What one way? This section is on compliance of the direction. Contained in the dated 31st of January 2022 passed by learned single judge, by which a writ petition preferred by the petitioner was disposed of with the direction to Chief Commissioner BBMP to consider and decide the representation and to pass an appropriate order in accordance with the paragraph in compliance of the order, the MP has initiated proceeding for removal of the temple in question and a notice has been issued on 21/6/2022. It is further submitted that requisite action in term notice dated 21/6/2022 shall be. It is stated by Mr. Srinidhi, Learned Counsel, that BBMP that notice that requisite action in terms of notice dated 21/6/2022 shall be taken within upper limit of 2 weeks. Full stop. The submission is placed on records. Accordingly, the petition is disposed. Accordingly, reserving the liberty to the petitioner to take recourse to such remedy as may be available to him in law with regard to his grievance, if any, petition is disposed of. Yes. Now, 23. Suitable orders and representation. Yes. That's what we told. We had asked previous occasion also. But when have you passed an order?
Yes, no, they are received copy.
See 8th November, 8th September, see the order.
We haven't completed the order.
You have complied. They have applied, right? You had forgotten about this contempt. You did not appear on the last day hearing. So we asked them, because Mr. Desai had said something else. So we told them to comply. It has been complied with or not?
It is not complete.
What is the direction
I consider the.
given for consider? What have you done? What was the grievance and what have you done?
I'll just. So, alternate plan of survey number 120. It has not been given. That is the survey that was submitted given. We are required to pass an order considering these representatives.
Yes.
Survey number 123 has been acquired. I produce the record of my money. Bank, alternate bank, and what is the apart from that one representative?
Yes.
The representative who. Our office and also from Madras office, their office was not that in spite of it, we are considering the representation.
Yes, yes.
Of an order to consider the representation. Our representation is, they are given a letter. Survey number 104, no compensation has been paid. They themselves written letter stating that we will give in survey number 123. But that they had themselves given an order that a copy to the complainant. Now, in the writ petition, they said we will consider the and they will consider that application. Now, without considering that application, now even 104 no compensation has been paid. They what they produce the documents respect of 123 only. Surrender 123, there is no dispute. We have received compensation. Respect of 104, they said we will give alternate plan. Vacant land in 123. I have produced the photograph. Whatever shows is a vacant land. What I produced the 14 Guntas land is still vacant. Without paying compensation, they have acquired several 104. For that, they themselves have written letter. We will give alternative land in surrender 122. They have never given. Now they come the supplement without paying order of the court.
Yes. All right. That's it. Anything else? Yes.
I also produced the sketch. It interpreted those produce the sketch and stating that vacant land in 123. That was also produced in the writ petition.
Yes.
Clearly stated.
I
They not comply the order of the Assembly.
Yes. Yes, madam.
The partial complaints, 1,00,000,825 rupees has been paid, madam.
But
It is very
that is
4,000. Petition is being sought, government to pay interest of 8%.
meet.
2 weeks.
No.
Emoluments of 4,000. 2 weeks time can be done.
Government council for that submits that the sum of rupees
1,62,825 rupees.
as the petitioner. However, it is stated that balance amount due to the petitioner
4,000.
of 4,000.
Sir, submission.
A submission. It is further submitted that balance amount of 4,000
Rupees, towards the
shall be emolument shall be paid to the petitioner within a period of 2 weeks. Line below, learned counsel for the petitioner submits that the petitioner is entitled to more than
1,50,000.
1,50,000, is entitled to sum of be that as it may, we grant 2 weeks time
Yes.
to respondent to make payment of the balance amount, the petitioner. If this petition has been filed for non-compliance, if this petition is filed for non-compliance of the in the order dated 8 June 2021, by which the petition is disposed of the direction to the respondent to decide the representation submitted by the petitioner and to pass an appropriate order. You in the beginning say in compliance of the order that whatever was the respondent is present in person. Then direction. The compliance report, we find that in compliance of the opposite direction, form of an order dated 8/9/2022 has been filed, by which the representation by the petitioner has been decided. The respondent has tendered an unconditional apology for compliance with the direction. Facts of the in case we are not inclined to proceed further. Liberty is reserved to the petitioner to assail the order dated 8/9/2022 in accordance with law. The aforesaid liberty. The petition is disposed. Yes, madam. Right.
Speaking order has been passed.
Counter affidavit. Right. To be considered. Page. Yes.
Three years of teaching is this is fascinating, but really come to this next step. But the ultimate opinion of the committee was that the petition would be regulated to. So, and the particular case, it complete this action. And if it also paid it to the author, the red gate has filled out all the findings of the committee as of extracted is an interpretation of adequately notification issued by ACT dated 4/1/4/16 clarification certain issues, anomalies pertaining to the qualification of pay scale, area advancement scheme, etc. For teachers, students, the ACT and it is between releasement in area advancement scheme, not it is appropriate to issue clarification. Simply to 11, which is their name. That is, relaxation in the APS codes. Yes, so to repeat the date of issue of it. It will be otherwise in the date of issue of the trading.
application. That because these are okay. Thinking comes to that skin color. It might be. Grant commission not.
Yes.
Each grant commission right. Take it through as extended. So it was a very. And it's with respect to 6 days, in order to say, the council too has decided to extend the date for completion of the oriented zones to 2008 grant. Motion. The various advance. This date, this date, but now for all the council candidates, pension uniform, all the applicants are expected to be above extension. The set public vote is clarified. Set vote is 20th May. Objection.
Taylor.
It is very clear. He said you are not. No complaints. Complaints. Order has been passed. You are not directed to pass an order. You are not reject.
Reconsider the light of observations made in the order. What?
And how can you say that it is compliant? You are an officer of the court. You don't understand the orders of the court.
Direction. Order was to reconsider the case of the petition.
Reconsider. There is observations made in the order.
Yes.
And even a date has been fixed. You overlook even that.
Considering all those aspects, only an order has been passed.
No.
File further reply.
Further reply. Reconsider, madam, in the light of order. We are recording your submission that you are stating so that it has not been complied with. Or we will say so. This petition has been filed for now. The actions contained in the order 26 by which the respondents were directed to reconsider the cases of the petitioner for pay band 4 scale of rupees 37,400 -67,000 with 9,000 after assessment of entitlement petitioner effect from a retrospective date and not from 7/11/2015. The respondents were directed to consider of the petitioners in the light of observations made in the order of the order dated 22/8/2023, we find that the claim of the petitioners have not been considered in the light of observations made in the order. There is no compliance of the directions contained in the order. Paragraph in view of opposite. The additional government advocate praise fund is granted 2 weeks time to enable the respondent to re-examine the claim and to pass appropriate notes.
Find on 9th of September.
Done. Right with what have you done? Direction, consider expedition in the light of orders. Oh, yes, all right. Yes, madam. Applied.
Cannot file your reply.
Not there. Council correspondent submits that reply on behalf of respondent has been filed on 9th of September 22. However, same is not direct.
Have you received?
Yes, next one. Yes. Order. Yes. So we dispose it of that I mark the present. This intra-court appeal has been filed against an order dated. Which order? 26/8/2022 passed by learned single judge. Appeal number 16807/2022, paragraph in view of order dated 30th August 2022, passed by Honorable Supreme Court in Supreme Court on 30th date, passed in LP 5155/2022. Nothing. The said nothing. The appeal is disposed of. It Supreme Court must have said so, right? They have said so, right? All questions may be agitated in the High Court. All right, this it is IA1 of 22 dispensation allowed. Yes.
Number 27.
Yes, CPC.
Okay.
It was to dispose suit at the earliest. It was. In view of decision of a 7-judge bench of this court in ILR 2000 Karnataka
1207.
120. This is not maintainable. Say therefore this
28.
office objection is ignored. Sixth time. Not interested, right? Sixth time. Consider the representation. Of course, in accordance with law. Yes. Where illegal? Where in Bangalore? Very market presence. The petitioner claims to be a public spirited individual. Which of the petitioner is with regard to the slaughterhouses which are being run without any license in Haveri district. Full stop. Petitioner had submitted representation on 22 to 2020, 2020 and 25/3/2020 seeking direction to the nature respondent. So who will decide? It had given representation to respondents regard to his take an action against the illegal slaughterhouses, the illegal slaughterhouses. However, the representation submitted by the petitioner have failed to evoke any response. The aforesaid factual background is petitioner. The counsel for petitioners submits this action to the Commissioner Haveri District, Haveri presentation submitted by the petitioner. Submitted by the Beyond and learned additional government advocate submits that suitable in accordance with law which shall be taken in view of submissions made and in the facts of the sport of direction. Take action on representations expeditiously in accordance with law. Be clear, no opinion has been expressed on merits of the controversy involved in the appeal. Needless to state that on that form. Accordingly, petition is disposed. You are not bothered about compliance of this objection, right? We have disposed it off. Otherwise, you would have sought weeks further time. Sixth time it is coming up. 3 months. Yes. More than 3 months you have kept it pending. Yes. Yes. The fourth time, not interested. They must have forgotten about it. Anything, no be. What is it? What is it about? Tell us. Wo. Ashuri, question notification. What is notification? Shari. EIL is service matter not maintainable, right? Huh? What is this notification, Anishari? Tell us. Yes, madam, what is it? No, not next time. What you have to say should not be called by outsource. Employees who have been illegally employed should be regularized. This is the PIL. Huh? What we are asking? What is it? Tell us. Please tell us. We will grant you time provided you tell us what is it. What is the PIL? What time it's coming up?
Yes, it has to be given from other.
Yes, that those persons are there. Litigation. At the expense of the persons who wants to be on deputation, right? And what has happened is when 12/4/21, by now recruitment must have been over. Everybody, that's why petitioner is not contacting you and you are not complying with the office objections. That's the reason. Have you found out what happened? So this was madam, this was an advertisement notification. So it has, by now the process must have been over, right? That's why nobody is coming. Influx of time. On account of influx of time involved in this public interest litigation has been rendered academic, even otherwise. Service matters, public interest litigation cannot be entertained. Line below the aforementioned reasons. Next. Which case? Next case of 30 also. What is it? Please. Your grievance stands redressed with. Please work soon. Government is quick to respond. Lastly, no license has been issued, right? That's it. Not granted. All right, in this public interest litigation, seeks the writ of mandamus directing the respondents 1 to 8 to take immediate steps to consider the representation of the petitioner. Learned additional government advocate points out that who has passed this order, madam? That Deputy Commissioner of Excise, Deputy Commissioner of Excise, Tumkur District has issued and endorsement dated 24/8/2022 that license has not been granted. Number 9. 9. In the industrial area. Full stop. The aforesaid endorsement has been produced by learned additional government advocate, which is taken on record. Paragraph. Of aforesaid, nothing survives for adjudication in this public interest litigation. So, right. No, that's obviously. Oh, you have succeeded, see, by doing nothing. All right. What is this? At the end of motion, other cases, at the end of motion hearing, it will take time, right? After motion hearing. Right. 1.4. Yes. Not lifted. We get it. 7th of September, you are finding idea. See, 31 point. Yes. Yes. We are sure Mr. Reddy will not contest your application. Yes. Yes. You consider. In pleading. Whenever this case is listed, he keeps it. We know these are the records of your case. See, Mr. Reddy. so intimidating. That's why we said that 6. We hope that you are keeping track of what's going on in matter. Something has been done. That's all. Mr. Reddy will tell us what they have done. Yes, yes. Which residential area? Any particular? Implement the state vendor. Problem. Basically, can implement vendor. Till 1 month. Government indicators. Upending of the sulfur. Without ending on this and the big back. They are when they go a bit for they may take assistance of it. Registration.
Talent. Completed in terms of 2000. Okay, sir.
Not 22. These rules should be implemented. We'll ask. Yes, madam, what have you done to make it? He says action has been taken. They have constituted committee. And they are. Yes, madam. No, this constitution of town vending committees, you have to do it, madam. State government shall constitute a town vending committee for each local authority. So first place, have you done it? You know, the rule says state government, please see rule.
BBMP area it is done.
For BBMP area done. Okay. All right, so when, how much time? Let's see. All right. Yes. Okay, this case,
very same writ petitioners are now submitting versus your.
oh, he has not opposed the prayer for impleadment. So we will permit impleadment. Status of commercial activity. Yes, fine. He is not without supplying a copy to you. So, that's why. Yes, that's why. So we are.
Eviction would come only after the entire process. And you can't.
Ah. It is confined only to flower vendors, right?
Yes.
So your grievance is that a commercial activity is being carried out in a residential zone without permission.
You are carrying out some in our own residential.
Ah, that's what he said.
In our own residential.
So then probably this act and this thing may be slightly out of scope. Right? And you are.
And if they have. Our vendor.
State did not come in and.
Non-resident are made.
So your application is for impleadment, right? Ah, yes. Right. To 11 and which anything. 8, right? Idea number of 2020. The application. Same out. The senior counsel for the petitioner submits that the events petitioner in this petition pertains to the flower vendors who carry on commercial activity in a residential zone without any permission. It is further pointed out that this court by an order passed had directed the BBMP to submit a report with who are carrying on authorized commercial activity in a residential zone. However, the aforesaid list has not been furnished. Information has not been furnished. Learned counsel, Mr. Srinidhi, learned counsel submits that the aforesaid information has already been furnished to this court on You haven't furnished this. Knowledge. For council threshold is granted, how much time? 2 weeks time. People are to seek instructions and file the requisite information before this court by on affidavit. Yes, what a date?
May I make a request?
Each
pending committee should identify.
We have, that's why we have
Some
recorded
steps
that,
should be taken to implement the directions.
but that issue is probably pending, right? You have filed a petition.
That is so right. The Chief Justice to
That we will do.
direction should be carried
We'll
out
find out.
in that way.
That's right. The street, see, please see the prayer in this petition. Has it been brought to your prayer is they should be restrained from carrying on their activity in the basement, ground floor, etc. in the residential area. They are not street vendors. You say that senior that the given not pertain to street vendors. You clarified this. And relates to the flower vendors who carry on basement and first floor. First floor and parking area of rest. Yes, which date, Mr. Srini? 26? 27th September. Yes. By the but that is the further there is an order of stay in your favor.
Fixing of seniority in my favor. That is not. Yes. We two are the competitors for the post. He has years of service. How about? Yes, he is.
In some time.
The second seniority, unsettling of lapse of 16. That's what lapse of 2. Dispose of the written finding.
You go on for some.
What is the answer? What is the interim relief which you have paid? All. Why these rankings have been modified?
I am pointing out to you, that you may kindly see, the expedition was allowed on the ground. I have not made a complaint for about 10 years with regard to so-called discriminatory treatment against me. At the ground, some expedition is allowed. But himself, when it's stated that I had filed a petition, there was an interim order to maintain status quo. Then, after the government passed an order accepting my contention that there should be a different as I will really appear in petition. But somehow the emergency has proceeded on the assumption that I have not made any grievance at all on the earlier. There should not be any change. It appears I education part present it was pending. But still to that, probably government considered the matter and was you have seen in the government allocated so and so. My impression it is no.
Yes, Mr. What did you say? Hearing on stay, right? It has been admitted, but tell us why stay should not be granted.
Now, he said the decision of that. From first promotion. It is not permissible. If the stay is granted, then he will be promoted to. That's why.
We had filed a late petition, right? Yes. What was that petition? Yes, Mr. Patil.
Number 7.
17.
0.
And
the application. Section of that, those documents go there, the order. The petition was not produced.
Think when was the order passed by the state government or whatever?
The
Something.
order
18 it would have been passed through. That's why you withdrew the petition.
4-7.
Then you withdrew the petition.
Then I tried 31/7/2019. The petition was dismissed as withdrawn. That was 7 but I have produced that memo for withdrawal. I have specifically stated in view of the government order that is so and so, my petition may be dismissed.
Action to respond to. Place the petition above the respondent number 3 and 4. The withdrawal was 151/7/2018. And this is a page 104 million. Report prepared on 29/31/2019. By doing the operation of the state, how they have prepared this system. Not though is not retained. This was published. It's not charged. Not raising a church. He said similarity is not permitted to unsettle of class of community. That is in the absence of any statute. Senior council is making submission regarding the order of the government. That is in the absence of any statute. 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 That is in the absence of any I am not aware of that fellow. Not resist, government pass the order. And what which are empowers to do so. In the absence of the same, is not entitled for any order. Same can seniority to the appellate below. There is no permitted below.
Yes.
Only the reason that I am having 15 years of service and the other person is having 4.5 years, that should not be the criteria to.
That can't be the criteria. No, what is it? Yeah. Yeah. What we calling dismiss for default. Oh. Oh. The reasons assigned IA 1 of 2022, order dated 18/8/2022 is recalled. Let office objections be complied with within 2 weeks. IA is accordingly. IA 1 of 2022 is disposed of. You first comply with office objection, right? Yes, madam. Yes, case 33. A number 2 of 2021. Learned senior counsel for the applicant submits that the senior counsel for the applicant submits that the applicant had assigned the rankings assigned to the applicant as well as the respondent in a petition named WP number 1080/18. However, the grievance of the applicant with regard to assignment of seniority was redressed by an order dated 4/7 passed by the state government. Therefore, the petition was withdrawn on 31st of July 2019. It is the single judge heard in holding that the applicant did not lay any challenge to the rankings assigned to seniority list. Senior counsel, learned counsel for respondent number 3 has submitted that challenge to the seniority list has been made after an inordinate delay of 16 years. Paragraph in view of the fact that in order favor of the applicant will be passed on 4/7/2019 and pursuant to which applicant had withdrawn the writ petition, we are inclined to we restate the operation in effect of the order dated 9th of April 20. IA 2 of 21 is disposed. Consider that. Yeah.
Can you take that? Government direction, right?
It should not take time. Yeah. Sorry, sir, you are appearing for point number 5. Learned assistant solicitor for point number 5. Praise fund is granted 2 weeks further time.
The question has not been considered by the Supreme Court.
Mr. Mahendra. Yes.
prospective given to he would have said that it should not create
You are aware, right? You are aware about that decision. That's what. All right. Yeah. Pending before learned council for jointly, learned council parties jointly submit that the issue is pending adjudication before SLP number 2518. Stop. Submission hearing of the petition is deferred. Meetings are deferred. Signed, I parties are granted the liberty to mention the matter as and when SLP is decided by the Supreme. Yeah.
Not a party.
I appear for respond number 4, my lords. 37, serial number 37.
Why should you place for adjournment after 3 weeks? 17 matters. Like this, why 4 years admission?
Last week you had short time to argue. Please read the order sheet.
That means delay is control. That means next date is for adjournment, right? No. Next date is for adjournment. It is set today for admission, Mister. That doesn't mean that it is fixed for granting adjournment. Then where's last?
On the last date, you have said you will argue on the next date. That is recorded here.
Four years, Mister. How long? 5 years. Appeal is pending. How long do you want it to remain pending? You argue day after tomorrow. No adjournment. Fact that appeal is pending since 2017. As no learned counsel for the appellant prays for adjournment. Taking into account the fact that appeal is pending for past 5 years on admission hearing. With reluctance, we adjourn the hearing. List on 14 September 2022. It is made for further adjournment on any ground shall be. Yes.
Rajaranti.
The appointment was appointed to detail of the court in the it's a bad the big law. Still there, relation part. It's all agreement.
Issue notice. Yes, right here. From IA1 of 2018. Mark is present, none for respondent those served heard on IA number 1 of 2018 for the reasons assigned in the application, duly supported by an affidavit. we find that sufficient cause for condemnation delay of 73 days in filing the appeal is paid out. Accordingly, delay in filing the appeal is condoned. Finally, 1 of 2018 is out. Third, on the question of admission, the appeal is admitted for hearing. If you notice. Fine. What? Filing? Sure. Yes, yes, got it. No, you have gone through it. No. Take it up tomorrow. Tomorrow, Mr. Saptar. Go through this. Interestingly, you told us that you are suffering a loss of 2 crores per day. That no, that finding is recorded in the order passed in April also. So since then you are suffering loss of 2 crores per day. Too much. So please go through. Please go through. We will let him go through it, and you file it, Mr. Ramesh, today. Tomorrow. They are in a hurry, right? So, you file it today. That's why we are adjourning. Rejoinder. What objection? IA. All right. Rejoinder to IA. All right. Learned senior counsel for you are filing. Learned senior counsel as well as Mr. Ramesh, learned counsel for BBMP, undertakes to file report and learned edition. Mr. Basavraj V. Saprat, learned senior counsel, learned additional comment advocate, and learned Mr. Ramesh, learned counsel for DPMP. Pray for and are permitted to file objections, status reports, rejoinder during the course of the day. List consideration of IA 1 of 22, 1 of 10, 10 of 22 tomorrow. 30, or whatever. Obviously, yes. Fine. Yes. No, you have to only tell us that the application seeking renewal was filed within the time provided for making such an application. Then
It's covered.
Covered.
This is 2020, not 2013. You are
This is
referring to an
2020.
order of 2019. This is 2020.
This is 4th February. No. This deals with, if you have not seen it, so this deals with an amendment 12th of August 2016, para 5. It has been quoted. There was a delay of, Mr. In your case, there is a delay of 11 months in making the application. So, whatever, 8 months, whatever. Yes. No, in order to claim the benefit of deemed extension, you have to demonstrate that you have filed an application within time limit, that you are admitting it's beyond time. Then how deemed extension, Mr. Simple? Yes. Rule 8. Right, it is considered in that this judgment. What a rule D, what a rule 8D, right? Sure. I think this is the latest judgment holding the field. Yes. You can file review, it has been overruled or reversed by Supreme Court. You can file review. Yes. What is rule 8A?
Oh, no.
Yes.
In a case, you know, the license also because like 7 months. You know, the mandate of provisions here it shall be extended. Even especially for in the delay in filing.
Yes. Okay. Yes. Rule 8.2 does not apply. Yeah. Shall not be 8.2. And contain the not affected by heat or the system heat minerals not affected. But the commitment of cannot come in with the conflict. Minimal has been detected or it has been determined or that. Can take it. That's it. Thank you. This one? 40. Yeah. 41. Yes. What you see, learned additional government get undertakes to supply another copy of what survey report? Survey report to the petitioner list after one. Wait. Okay, so this what is all that could allow all this. Third on IA number 1, an application seeking condonation of delay of 841 days in filing the application for recall, line below for the reasons assigned in the application, duly supported by an affidavit, we find that sufficient cause for condemnation delay. The application for recall is made out. Also heard on IA 1 of 2022 for the reasons assigned in the application, order dated 8/1 15/3/2019 is recalled in the result. IA number 1 of 21 and 2 of 2022 are allowed. Full stop. Line below, since the matter is already listed for hearing, no orders are required to be passed on IA 3 of 2022. The same is accordingly disposed of. Addition in this writ petition, the area. Petitioner inter alia seeks a writ of certiorari for quashment of order dated 11/12/2017, passed by the Joint Director, Department of Mines and Geology in revision, by which endorsement dated 20th February 2017, rejecting the application filed by the petitioner seeking renewal of the lease has been cancelled, has been affirmed. Paragraph. Facts giving rise to filing of this petition briefly stated are that father of the petitioner was granted a quarry license for extraction of building stone. Building stone in respect of land bearing survey number 368, measuring 0.30 acres. AUTHA in UR village, Gundalpet Taluk, Chamrajnagar district. Chamrajnagar, comma, years on 27/1/2000. The application for renewal was filed. The period prescribed for making the application 31/8/2016. Full stop. The same was paragraph. The same was therefore rejected. Paragraph. The same was therefore rejected by an order dated 31/8/2016.
20
Passed by
22/2000.
22/2017. Sorry. Application was filed on 31/8, right? The aforesaid application was rejected by the competent authority by an order dated 20th February 2017, and the order passed by the competent authority was upheld in revision by the regional authority on 11/12/2017. In the aforesaid factual background, this petition has been filed. The counsel for the petitioner submitted that in view of Rule 8 within bracket 2 of the Karnataka Minor Mineral Rule 8A within bracket Rule 8A within bracket 8A capital A. It's not within bracket 8A within bracket 2 of the Karnataka Minor Mineral Concession Rules 1994. The petitioner is entitled to renewal of the lease. Learned additional government advocate has placed reliance on Rule 8 within bracket Rule 8A within bracket 8 of the rules paragraph. We have considered the rival submissions made on rival submissions and have perused the record. Full stop. The controversy involved in this petition is squarely covered by judgment dated 4th of February 2020, passed in WP number 45199 bar 2017. Full stop. It is pertinent to mention here that admittedly in the instant case, the application for renewal of the lease was not made within the time limit prescribed therein, has been filed admittedly, belatedly after a period of after expiry of the lease. Full stop. After expiry of the lease, Rule 8-A within bracket 2 of the rules has no application to the fact situation of the case, and rule 8 within bracket 8 of the rules apply, which reads as under quote, right? The 8A8, right? Page 52 of this paragraph. The line below, the application submitted by the petitioner was deemed to no the petitioner was adapts as the application for renewal of the same was not filed within the prescribed time limit. Full stop. The bracket 8, comma, the petitioner is not entitled to renewal of the queries. The application submitted by the petitioner seeking renewal of the queries therefore has rightly been rejected by the competent authority, and the aforesaid order has rightly been upheld by the revisional authority. Paragraph for the aforementioned reasons, we do not find any merit in the petition. The same fails and is hereby. Not entitled to deemed extension, right? Not renewal, deemed extension. Extension. Yes. Yes. You want to withdraw? Statement of objections, Mr. Huh? Word by party presence, learned counsel for the petitioner prays for adjournment to enable him to carry out the amendment. Learning the additional comment advocate submits that content involved in the petition is squarely covered by an order dated. Give it to her. Order dated so and so forth. The passing point in view of aforesaid submission, learned counsel for the petitioner adjournment to enable him to examine the aforesaid aspect in the next week. All 2019 matters here pending. Yes, Mr. Oh. What? Okay. Yes. Right. Show notice to respond number 5. List for orders on admission as soon as the respond number 5. Number 40. Number 5.
You are not appearing for respond number 5.
Yes, selfie is decided. Pending. Learned additional government advocate submits that specially petition is still pending before Supreme in view of Honorable Supreme Court, right? Paragraph. In view of official submission, hearing of the petition is deferred. Of hearing of the petition is deferred. Parties sign it. Line below, parties are granted the liberty to mention the matter as in party side. How many polls? 1,433
remain to be shifted.
5,000.
784.
We done in two phases, first phase is completion. But
You have to file a right status report. Filed it. But so I out of 57841433 remain, right? Then how will you remove first and second phase?
But first, I'm mentioning the first phase.
How many poles remove?
In first phase, number of poles removed is transformer effect is 3,194.
3,000.
194. In second phase, but 2,588.
Poles or transformer? Transformer. All right.
Phase 3,155.
Opposite.
Divided 1,000. Remaining road to be.
So how much time further?
2023. Construction started by January. You have a setback not because of the- But in the condition of keep us on. Work it, we can't be still on. Keep us on. The custom is still on. Pieces of limits.
Waiting for some made or not, this one has been made, right? They are doing it. Ah, market business. Compliance of the order dated 18/4/2022, Learned Senior Council has filed a memo, has filed a compliance report. Compliance affidavit on 9th of September. The compliance affidavit, which is evident that out of 5,784 transformers which are situated in the midst of the road, are on the footpaths of the BBMP, 1,433. Only 1,000, no, not only 4,000, 1,433 transformers are yet to be shifted. Full stop. It is first phase. You have 3,194. You have done, right? Learn line below. India Council for Respondents submits that in the first phase, 3,194 transformers have already been shifted, and in the second phase, the shifting of 2,588 transformers have been undertaken. Out of which, how many? 1,055.
1155.
Yeah. 1155. Out of which 1,155 transformers have already been shifted. It is further submitted that for shifting of remaining transformers, namely 1433 number, tenders have already been invited. The work order has already been issued and the work is in progress. Full stop. The enforcement submission is placed on report list after 3 months. So have been shifted up to, you say, September 2020, right? Or what, 9th September. As on 9th of September, 2023, right? List after 3 months, 22 to, or 22, right? Say when list after 3 months to enable learning senior council to file a further status report. But, so when are we reopening after Mr. Mohan? Huh? January. January, New Year. New Year. So what Mr. Yes, Natash, New Year, would take January. Ninth January. 9th January 23. Assessment has been taken. Which, all right, so which judgment has been distinguished? Judgment? Srimati Nagubai. Dr. H.S. Yes. Yes. Admitted for hearing. For hearing, and Mark is Mr. Manju Reddy, Learned Senior Counsel, with Mr. G. Lakshmi Sharma, Counsel for the applicant. None for respondent, those that admitted for hearing. Heard on IN number 1 of 2021. Learned Senior Counsel for the petitioner submit that learned single judge heard in distinguishing the decision rendered by division bench of this court in which case BDA versus Dr. H.S. Hanumattappa, which is reported by INR 642. So and so, which applies to the facts of the case. In view of submission, which in the effect of impugned order shall remain still. Let's say none for remaining. This to serve.
My lord, I appear for respond number 6, my lord. I have filed my objections to the applications.
Application.
For stay and direction, my lord.
Okay, so what to do? What race one is granted a week's time to counter affidavit. To file counter affidavit. Objection filed on behalf of number 6. Yeah, we have granted you week's time. Next week. Just in the praise for adjournment to enable him to file so and so list in the next.
48.
Much obliged.
It is Pradeep Kumar, Lal Gopal. Consent award, not permissible.
Granted consent. The SLO case which is there is a dispute, he does not rely on the consent.
Appeal has been admitted for hearing, right?
No, no.
Not yet. Yes. What do you say? Is it a consent award? No.
Consent award. But my not so the 2001 they have taken this from me, and land was acquired in my name, and they have taken possession. NDC not annexed ABC. And there are two lands for acquired. That's the other land in law. Just fire. And there were also big just and different from the order not asking respect I don't know. Respect the 107 order, this is the matter. Who ranks the law? Who ranks for acquired? And from his possession of I have given consent. 14 lakhs we read the compensation awarded. And I have given consent. But in respect of what is the and the compensation to 33,000. I will start in the first of same notification, same award. The same card and ADC got a pay. This is in respect of 108. And now I filed expedition because there is no dispute with regard to 107. But there is no civil dispute. The 107 dispute. For this is the order in order to 50%. And 50% as subject to income dispute. So that case on the basis of the like the other is one to pass the direct no. We will record the vote in the last portion on page 50, page 70. That directly is recording. Right. While ordering the direct to be modified, when order all the direct to be modified and exactly to so 50% from the now who is direct it is from 20 to so then the balance amount is direct kept in fixed deposit in a national bank in interest payable. The matter was heard on earlier on phone. So this is what the order. The matter was in 2 weeks' time, we will grant it to complete the order. And if we grant complete the order, it will be etc. Then we order 33 million of what you pay. Okay. Then we party the counter of it, and the award has been passed on 5970, resulting into fixing the compensation including interest of 2,70,000, 39,530. They are better and then on the issue. But either the compensation because fixed at rupees, fixed of rupees 39,500. As sliced down to the rupees 2,10,000. Now, the opposite difference is as no valid difference. But by passing the order, but this is the effect of 108. 107 is not subsequently they passed the same award. This not that award has been set aside. I think by passing the award, Section 5970 has been created to accused to interest in overreaching the judicial process. That too by filling those parts. The report order, the order as such, in effect, is sought to be nullified. Act suggested. And we are said that we pay amount differ. Then your article can become not the page 138. That gives page 130.
What has happened to that case before the civil court apportionment?
That is subject order.
What has happened to that?
108. This is the effect of survey number 107. When Vimala was owner, our district not, he had not filed any case. That is in the effect of 108. There was an order made out in the requisition. I may not have recovered. This court will have a contempt court said, in their order, because also, that has found your particular case at page 140. Same lands, two lands, I purchased two lands, same notification, same agreement, same award, at page 140 in in such circumstances, users that provided in law under section 34, the act has to be calculated and paid.
Deposit, this will be abide by the subject of the subject. What is there? They are deposited.
No, consent award, flower.
There is a direction, right? Cannot be deposited means what? Cannot be. There is a direction, right? We will hear that writ appeal. Why should you, supposing if you lose, you will have to pay interest on this entire this thing amount, right? No, that doesn't mean that you will not pay compensation. That will be decided. We are not permitting them to withdraw the amount. You deposit, there's no question of granting stay. Appeal is admitted per year. There is a direction, Mr.
Compensation at the rate of 14 lakhs.
Word on. Word on IA 1 of 2020. Yeah.
But as far as the interest part is concerned, getting deposit. Principal amount by the rate of 50 lakh.
Amount only we are directing him to deposit 14 lakhs. At the rate of 14 lakhs, interest part is being stayed for them.
That is paid because there is no dispute with regard to that not. There is no dispute with regard to that.
No, but it's not a question. They are not. We are hearing him on stay, right? To make an application, because let them first deposit.
There is no dispute with regard to the one.
Heard on IA. We are not heard on IA number 1 of 2022. Counsel for the party, it is directed that the applicant shall deposit the amount of compensation at the rate of rupees 14 lakhs per acre in respect of land bearing survey number 107, measuring 2 acres and 33 guntas. However, the direction to pay interest in terms of section 34 of the Land Acquisition Act 1894 shall remain state in next rate of it. Yes. 1 of 20. Deposited before the civil court, right? Civil court. What having the single judge has said no 14 lakhs. So there is a direction, right? 14 lakhs to deposit. Government advocate. Test analog is carrying along with WA number.
Lord, I appear for respondent number 5. Lord, I
yes,
appear
ma'am.
for respondent number 5, my lord. I pray for 2 days accommodation, my lord. I have to file objection to the IA filed by the other side for stay. 2 days accommodation.
Learned counsel put the applicant just required if learned respondent is granted a week's time to enable him to file objections to IA 1 of 21 list in the next week.
Great, great.
Respondent authority invited.
So, para 7, only thing is that you are granted the opportunity to produce computer proficiency certificate and you have not produced it.
Two serial numbers, yeah, repeat by the respondent. Remember.
You are challenging the appointed respondent as first division assistant on what ground?
So, security less.
Why less marks? So why he secured less mark? What ground?
The appointment.
But each para has no
So how do you meet this reasoning, right? Ask.
Learner single judge just said that you have not produced material with regard to computer proficiency.
We are going to
Listen to question first before responding. Right? We are not doing anything. We just listen. What is?
You have not produced any material with regard to the computer proficiency certificate before the authorities. Where have you produced? Where have you produced? Not MA with regard to your computer proficiency. Notification inviting application says para 7 of the order. Please read para 7 of the order.
We are not producing costs. Because it's not correct. On the other hand, in the MBA course, 8 computer papers are studied or the period. On the other hand, paid to the respondent to a producing 2 documents. Paid to the 97. Producing one experience, paid to the 14 page number 9. And this is produced by the respondent. Next document below is annexure 50. Is by the respondent about the experience. In the document, these are parts of anticipated learning function. Consider. And also, the another one document is produced by the respondent number 2. By passing the 8 subjects in the enforcement.
only certificate is document certified respondent number 2. Page of 14. Next time. Not a the earlier said C and out. There is no C and out that is that's also mentioned that as per the C and out.
You had not questioned the notification. In the notification that it provided that the computer proficiency certificates are required to be produced. You have participated in the interview. Can you say that that is not a requirement?
For appointment order, for my friend to the authority, respondent number 1 authority. Okay, when appointment letter to the respondent number 2, because that otherwise not communicated or not, that's why the yes, for my lord, the respondent number 1 authority has issued this order. Here to order the issue, appointment order to the respondent that shows that they
That's it.
When at the time of the interview, they were asked to give an opportunity to proceed.
That's it. Okay. Thank you.
One authority, just give and me, has given the appointment 20 is
Thank
is arbitrary.
I apply for the current space.
Yes.
So we feel is quite challenging the order of the land single judge. But petition was filed for challenging the award of the labor court. Ashok may kind of Peru. Labor court not rejected the claim of the petitioners on the ground that they have not completed the
The only thing is delay of 13 years.
If I in the case also, I refer, you will not make title for the
Yes, Mr.
yes, Lord. But very Lord, the finding of the labor court in regard to petitioners are concerned, Lord, they have not completed 240 days of their service. But hardly they have worked for 126 days, 177 days, 135 days. Lord, for that reason, Lord, labor court rejected their claim.
97 to 2000, right? That's the finding.
Yes, Lord. It is
Paragraph 5 is the finding 97 2000. That means 3 years.
Lord, in regard to other claimants, but in regard to petitioners are concerned, the finding is at in page 110, Lord, internal page 32.
There is a finding, right? 240 days.
Yes, Lord.
Calendar days in a year they have completed. So why we should interfere?
So there were in regard to labor court award, Lord, there were claimants about 5 claimants. Out of 5 claimants, Lord, 3 claimants petition claim was rejected, and the other claims, Lord, it was partly allowed. But now petition was filed only by the petitioner, Lord, whose claim was rejected. But the finding in regard to those claimants, Lord, labor court held that in regard to, may I read your lordships in page 110, internal page 32 of the labor court award.
Yes.
Yes, internal page 32, Lord. After about 9 lines, Lord, on perusal of the list produced by the respondent management regarding service particulars of the claimants at exhibit M1, the claimant number 1 so had worked during 97 and 98 in all about 177 days. It is also evident from the documents produced by the claimants at exhibit W2 and W7 and by the respondent management at exhibit M11 and M12. According to M1, claimant number 2, GM Shivkumar had worked from 95 to 2000 in all for 970 days. Claimant number 3, Mahadevappa had worked for November 99 to March 2000 in all about 126 days. Claimant number 5, Gopal Nayak, had worked from November 99 to 2000 in all for 135 days. In regard to petitioner's concern, Lord, claimant number 1 is one of the petitioner, Lord, and claimant number 3, second petitioner, Lord, and claimant number 5 is the third petitioner. First petitioner, Lord, has worked for 177 days, and second petitioner has worked for 126 days, and third petitioner has worked for 135 days. But considering these facts, Lord, the labor court rightly rejected the claim of the petitioner, Lord.
Lorry counsel for the petitioners, while inviting the attention of this court to the award passed by the labor court sub award dated 12/5/2017 has submitted that respondents have not rendered service for 140 days. In view of the court's submission, we should notice on admission IA 1 of 20.
Okay.
Yeah, number. One is dismissed as not.
Serial number 53 for the appellants, Your Lordship. I pray for 10 days time. We were supposed to produce certain documents evidencing that the BDA had in fact completed notification, the final notification process.
IA so and so disposed of, right?
Yes.
Then learned counsel for the petition, learned counsel for the appellant praise is granted 2 weeks time to enable her to place on record the documents to show that the proceeding of land acquisition was completed by Bangalore Development.
Much.
Yes. Yes.
54.
Appear for respondent number 1.
Penalty of dismissal after departmental inquiry, you have secured appointment on the basis of an incorrect mark sheet. What inconvenience? No.
Next week, any day.
What did we ask you? You have obtained an incorrect. You have obtained an appointment on the basis of incorrect mark sheet. Departmental inquiry was held, services terminated. Dismissal has been upheld by learned single judge. What inconvenience? No inconvenience.
Yeah.
Read Mr. all the files and then seek an adjournment like this. Hey, what did you do? Tell us. Senior is all right. Senior is senior because he has argued so many cases. When will you become senior? When will you become? Monday. Oh, great. What's your name? What's your name? So we will adjourn it with this. What's your name? That Monday you are going to become senior by arguing this case. Great, great. What's your name? Tell us. You come and ready with the case. What's your name? Learned counsel states that he will prepare the case and argue the same list on Monday, 19th. Right? Why?
11/8/22. ACB has been held in the appeal filed by the ACB. Now the files are handed over to local examiner. It may be amended by the local examiner.
No, not two. This is 226 and 227, right?
Cash. Cash.
How you could have maintained a 482 petition as a discharge order? You should have filed a revision.
We had filed my lord that. Did not take up any.
No, this is not 227, Mr. 226.
You have
226 was this number. I can see it. Because
From perusal of the order. Order dated in July 2021. Passed by learned single judge, it is evident that from text and tenor of the order, right? From the text and tenor of the order dated 22nd July 2021, passed by learned single judge, it is evident that the same has been passed in exercise of powers under Article 226 of the Constitution of India. Therefore, the objection with regard to maintainability of this appeal is overruled. Yes.
look, may I make look,
Issue notice on behalf of respondents is accepted by learned. Acha, you are already appearing, right?
Yeah.
Notice is accepted.
look, would there be, my lord, this thing is not actually not good, because it would.
We have held 226, right? We have held it 220. There is nothing to suggest. The single judge has not said it's 227. And you said 482.
Yes.
Nothing.
An application filed for discharge to 27.
Hey, it was your petition. They not 227. It's 226.
No,
only.
there. For discharge.
What does Pepsi Food say, Mr. Pepsi Food Supreme Court has said 482 or 226 nomenclature. They have not said 227. 98.5 SCC. There's nothing to why they should be deprived of right to file an appeal. If facts justify filing of a petition under Article 226 or 227, both, the court should construe the same as one under Article 226, so that the right accrues to the aggrieved party of filing an appeal. Why we should construe such a manner that it's 227 when single judge doesn't say so? This all, I mean, you better get ready on merits. Yes. Yes. Fine. And so it will continue, no? That whatever has happened, you will have to formally amend, but that you will be continuing with the cause, right? If it is, that doesn't mean that this appeal is gone. That's what we have saying. Yes. Next.
Government advocate.
Okay. On land, right? Then. No, that's fine. You should tell us why delay should conclude, why, how, what is the reason for delay? Why we should issue notice? That you should tell us, right? Here. Document says that he was on. Then, why next week? What have you done during weekend? Why next week? Same thing. Why? What is it? Tell us why it should be converted. Tell us 772 days in filing the appeal. Why notice should be issued? Tell us something. That's no ground. That doesn't mean that you can't. That's what we are asking. We have gone through, I mean, the file. Why you did not go through? You are a young man, you should argue, right? Why do you seek adjournment? Only unjustified measure. Condonation of delay. Tell us 772 days prima facie reason why we should issue notice.
Who was not well? Mahadeva is the party. $72? Anantamurthy has expired in the year 2018.
Why you should? That's what we are asking. Maybe we should impose costs for seeking adjournment, right? Cost. You should pay no cost next week, subject to 2,000 rupees to begin with is fine. No, not ex-serviceman is not seeking adjournment. You are seeking adjournment. You will tell him that the court was dismissing your appeal with great difficulty. I got an adjournment. Will you tell him that the court was ready to hear? Court had come prepared. They were asking questions. I did not answer. Will you tell your client? He will take away the file from you. Not ex-serviceman, Mr. Ex-serviceman has in good faith engaged you, thinking that you will prepare the case and argue. He doesn't know that you will not read it and you will seek adjournment. And the court will read it. Court is asking question to you. You are unable to answer. He doesn't know. The way you are defending his case, the way he would have defended the country, what would have happened, you can imagine. He did his 100, he gave his 100%, right? You can't even prepare. We will appoint some amicus curiae you are unable to get ready. We'll appoint somebody. Who do? Ex-serviceman, we have to examine ex-serviceman. Fortunately, making false statement, I mean, above all this, you told the council is unveiled 2021, he has expired in 2018. Fair, Mr. Not. How do you manage? How do you manage now? The proceedings are live streamed, right? Your clients don't question that. They don't see your performance, right? How do you manage? We are accountable to people, Mr. Please appreciate. It's all live. Keep on seeking adjournment for nothing. This appeal is delayed for this thing, and again you are telling us the same reason. Council is not well. Council is not. That's why 772 days delay. Again, he is not well. You are well, right? You tell us. You argue the case. You are. It's not your case that you are not well. Tell us. Password. No, nothing. Password. No. You prepare. We want you to prepare the case. Nothing. Why should we grant adjournment on condonation of delay? We are see, Mr. We are not going to tell you how to argue an application for condonation of delay. If you don't know, ask Mr. Nanjun Reddy is sitting here. Ask him what should I tell? Ask him, he will guide you. This can't be done like condonation of delay. There also you will not tell us. If you don't appear in second round, we will dismiss it. 7. What review? Matter is pending before Supreme Court. Is it so, Mr. Patil? And without notice to him. 57. So you have two grounds, right? That it has been passed without hearing you, and the matter is pending before Supreme Court, which is not taken note of this by. Yes, Mr. Patil. Right. So, no, but was he heard? Was he a party to the? Oh. This is dispatched with his. Mr. Patil, was it dispatched with?
Yes, women who needs to try a solution. Actually, the extent of land that he claims was the layout and development. It can be sanctioned by DDA and the said extent is to be made of the evidence. Then alternate I need to get my society for providing a area or it's a DDA. Extent where required and over. And where are we going from art space, open spaces?
What is it? Supposing you would have been heard, what is it? What's it?
It is allowed in the Supreme Court. This land then excuse me.
Think that the past relying upon the number 269. I think the subject. I think the subject is to be political. 290.
Yes. Supposing if his petition is allowed, yes. They same judgment, right? Same judgment, you have filed a review petition.
EPFP is not a quality test.
Yes, Mr. Patil.
Someone will take line. Giving side numbers without indicating whom it belongs to. It is the society which formed the name. All that I am saying is show the name of the society. Spaces. Whether they architect or anything. Vision. Otherwise, it is handed over without any.
One difficulty, Mr. Patil, that see para 8, having this appears to be submission before this court, that judgment dated 28/12/2019 in W8 2690 of 2015 is the basis, right? I mean, is relied upon. And that is the subject matter of special leave petition, page 46. What would fact it will have? Here you may not be like, it still demonstrate that it has nothing to do with that, right? Yes. 42/41. This petition has been filed. See, of the judgment dated 19th of July 2021, passed by this vote in with 983/2019. Taking into account the fact that the order has been passed without notice to the without notice to the appellant, and the fact that against an order against against the order dated 2011-2019 passed in WA number 269 but 2003, the fact that an SLP is pending, to the notice of this court, the aforesaid judgment is recalled. Result number 983 but review petition accordingly. The review petition is allowed. In view of the order passed by us in RP number 2, that order is required to be passed in this RP. Review petition accordingly same is disposed. Pending interlocutory applications if any. But the delay is condoned, right? Delay is condoned. One delay you say in the view. And pending interlocutory applications are disposed. Yes. 58. How many did you get? You have not filed any application, right? Survey number 224/8 and 224/9 you didn't file. You found that he is lacking 224/8 and 224/9. And then every interest. Yeah, we are number 2. There is no claim. Once also equal was rectified without still 670. Yes. As only obviously you have to get which is paid by the patient and the because patient not
Read the next para also, para 8. Read the para 8 also.
What happens to earlier order, Mr.? That's what. Here. That's it. Anything else? Yes. That I was into the last system. 1 minute. Good. You want to argue case, we will hear right now. But seek an adjournment, right? There's no urgency. What we will reach 59 within before 3 o'clock. I think we will reach. You want to argue right now? No. Why? Huh? Huh? 67. Count. We don't know that they don't want. We fight an elaborate one when we are granting time. Huh? Why should you spare us by filing a brief? Huh? Grace for 67. Yes, what's your case? You also now tell. You will adjourn your case also. That's the problem, Mr. You should always, there was Mr. Counsel, we are telling you, no urgency in seeking adjournment. Right? You are not there in the second half. That sets an example for younger generation. Imitate you. Nothing, no urgency in seeking, great thing about seeking 2 weeks time to file reply. You are not saying that writ of mandamus, we would have appreciated that. Please allow his petition and we will consider. You are not saying that. Yes, Mr. Which case? No. Now you also, since we have granted 67, why should you feel? Come, which case you want adjournment? 59. Why do you want an adjournment? Give it. Right, fine. What is it? What is the case about? So you had never claimed the land, right? Form number 2, never this thing. Admitted position. What to do? An application for amendment. Senior is in hospital. What happened to him? Operation. So when do you want? Pray for adjournment on the ground that the arguing council is list on 20th September 2020. Seek an adjournment on the next date.
For any information, we will copy for half an hour, except giving information. You don't elicit the information, like I don't do. We don't. Not very. Chat. I don't copy because you're not happy. So this is.
The Ashok Narayan, government educates. My lord, the police have issued the amount and cancelled, executed the agreement and the agreement indemnity. Second, my lord, the other signature is 9% interest on the consent amount. And we have intended in my lord, the agreement, there is no emergency. Agreement is obtained by fraud or misrepresentation, or that has been set aside by the other signatures or any conflict. So long as my lord, the agreement is in force, my lord, they are not entitled to seek any relief for paying additional interest. But I have relied on the judgment of the Supreme Court in Singapore, therefore, there are judgment of
One citation. Citation.
that I put it. Right?
Tell us.
Yes, yes, I'm fine. Sir, I'm fine.
So you say that interest would not be payable in case of a cancel.
Let us say on the basis of lot of misrepresentation, or there is inspection at all, para number 13, ma'am.
Already.
Okay.
Fine, fine.
And
Agreement is binding on them, right? Fine.
my lord, last judgment, my lord, one division bench of this court, I should, but I am also put it at 31 of. At 31 of.
Which judgment?
Division bench, page 85. And similar circumstances, my lord, this court has held that, my lord. What is the judgment of?
Para.
Para 31, my lord, page 85. Because we have no institutional holding that event of an agreement of the state government and the person to be compensated. Once the agreement is signed and agreed amount is paid and accepted without amount of protest, cannot turn over and seek position or interest on the market value unless it seek a declaration from the court having an agreement is violable in terms of the provisions of the Indian Contract Act, having been obtained without position, etc. The restriction of Article 56 of India or the relief as sought is not visible. Apart from that, the learned senior judge has relied on the judgment of this court, my lord, as per annexure. this court in earlier page number 55, 52, my lord. They have filed, the respondent filed a requisition seeking, my lord, seeking consent award. This court, my lord, this judgment, since the right has not yet been decided by the revenue authorities, so general award could be passed and deposited to civil. Meanwhile, what has happened, my lord, deputy commissioner has decided the title, and in view of that, my lord, they have sought for payment of consent award. So according to that, my lord, the consent award is paid by the land acquisition officer, my lord. Also, may kindly see that the indemnity bond and agreement, page number, my lord, 100. Also, may kindly place 99 is their indemnity bond and agreement. And they specifically stated, I undertake that I will not approach any court of appeal. And regarding, my lord, the judgment of that matter, my lord, they have challenged the general award passed by the land acquisition officer. My lord, they have not been by the revenue authorities. The government is decided and not may be considered once the right is decided, they are entitled for the interest of the payment consent. That is entirely different. Here they have seek for consent award, then it's that they directed to pay the general award. In the meanwhile, they themselves take the consent rate. That indemnity bond and parliament is not this is district. Say that
Yes.
that it is concerned that limit is not at all applicable to this case, because in that case they have not taken the amount of the consent at all. What should be kindly bear in mind, provision in that. The general single just stated that, my lord, we are not party to the consent agreement. It may not be correct, my lord, because earlier judgment, what should be kindly bear in mind. The themselves have agreed that, my lord, agreement, page number 52, judgment page number 54, my lord. Agree. The choice of period, yes, agreement. For the petitioner submit that and in question was granted to the petitioner as petitioner has participated in proceedings both before the consent award. So observation of the learning that may not be correct. Participated, they can be
Yes. 99. What agreement? But this agreement, right, it has not been challenged before any authority saying that void ab initio binding something. That you are entitled to interest on this amount. Yes, yes. So you say agreement is void. Huh? Agreement. Pay compensation, right? Similarly situated owners have been paid. Who have executed an agreement. No, the funding is the same position, original petitioner are also paid compensation.
Okay. It is entirely different case. That case may not, that I may not decided. It is the challenge before this court. It's to the candidate my lord. I decided in that. I mean, don't thought.
All right.
Who carries it? Who will pay to me? And carry to me because and gives me 62 lakhs. This is what these total products because of by using the property and one of the plants are paying the money compensation. The estate existed.
But in the present case, I already not need to be. And before the price are going to be. Oh.
Who are the similarly situated persons, Mr. That is, as in two paragraphs recorded the same finding that similarly situated persons it has been paid. If that is so, perhaps no case is made out in part in your case. But who are the persons who have been paid like similarly placed? Now wait. No, that's all right. Ah.
If you are required, you are not belonging to the. But a single is a liberty to the government to initiate. But said ultimately it is that they are the owners in 9%.
This is the document because the
Is it? Yes. No, we are on this point that if it has been paid to similarly situated persons, you are also entitled. Ah. I can see we can see the figure.
In case not by KIDP. What is annexure C? Annexure C. CC.
See.
Notification very same. Question there. Was it the very same? Was it the very same acquisition? Annexure C.
Yes, see at 64. 64. Oh, yes. 3rd of April 2014.
Passed by single jet. C.
A 64. What have annexure C. 3rd April 14. Oh, we are asking whether it's
counsel for the appellant. What is annexure C?
Annexure C, annexure C, that was the wellness scale.
Yes, I have made submission, my lord. Election C, my lord, we have passed the general law. The guideline was being decided. So in that event, we have challenged for this for the general law. So honorable court has held that, in the event that right decided in favor of them, my lord, they are required to pay even consent to 9% interest. In those cases, my lord, they are not taken the consent of. These are my lord, the general page number 29, parallel number 11, that is my submission was taken on record. Page number 11, what may kindly see? So and so, let's submit the petitioner cannot rely upon the decision of this court in WP 1570. And impugn the general award determination under section 29(3) of the KID Act without receiving any compensation under the section 29(2) of the KID Act. That is what the petitioner Srimati Ekaya has received the compensation of the KID Act. Petitioner cannot treat directly in such interest. It is only my. They have not received any consent amount of the support. Yes, they can have a instrument agreement. There is no argument with regard to any fraud or misrepresentation. What agreement may not in a contract. In this case, also. Regarding the transfer of the amount, this is the land acquired entire to the government. Government in communication may not have made some excess amount. That will be returned to the government. So, ultimately, compensation to be decided by the acquiring and acquisition. They are the owners emitted the amount, now some excess amount they have paid, limited. But as per the consent is concerned, as per the core consent, they are agreed.
Who are the persons to whom have you paid the amount? Like learned single judge has said similarly.
Question number 97003.
But is it the same?
Yes, it's same, madam.
Yes, para 2, page 58, you read that last para. Page 78.
In the case of the petitioner.
Yes.
Case of the petitioner, that is, so far the payment of compensation concerned, there was an advisory committee constituted by the state government consisting of deputy commissioner, as trusted special acquisition officer, and joint secretary district informed. Such committee after having get clear that landowners are said to have Karnataka 52 lakhs per acre was payable as compensation for the landowners to voluntarily surrender the land. That recommendation was accepted. Land was also taken by the SLO year 2009. The names of the petitioners are said to be found against the list of land. As further, that demand the payment of compensation report had verified that bona fide from the Tahsildar concerned as to the petitioner having been recognized as the landholders. The respective
It's a consent award, not the general award.
further, that petitioner.
No, here also.
Yeah, I said that my lord,
You said it's a general award, it's not a general award.
that's our general award is fine. You will conclusion. First pair of the prayer. Expedition, my lord. Expedition file, page 55. Expedition file under order 26-27, Constitution of India, saying to directly grant the general award dated 31/12/2012, to by the first court dated 11/10/2013. The award notice dated 20. How can it be general award not be paid consent because the time cannot decide? We have filed the general, of the general award and we will take it before civil court until the time is decided. That's the matter where the court has finally not to kindly take parameter. Page number 83. Yes, let me make clear.
First that. Wait up, general award. Chitterpedi.
Yes, anything else?
The learning of educated proceedings have not been initiated against the petitioner by issuance of notice of the the petitioners ever unstated so there should be no impediment to consider the case of the important rightful amount. State government from this competent officer may proceed with the action initiated in accordance with the law and it is up to the level of the petitioner. If we pay compensation in terms of the new government award with interest of 9,000 per annum, the date of taking possession of the land is. Not the there must be a provision to protect the such iniquity. This for the purpose of opposing this purpose was become interest money is there and it is
All right.
it was not against them. It was
You told us. Right. You can- that illegal structure. Issue none for the petitioner record issuing notice.
I'm appearing for petitioner in the matter, my lord.
You are not appearing what to do.
By the time I switched it, I heard the orders, my lord.
Right. Mark is presence. Good.
Much obliged, my lord.
Number 62, the Rahmatullah Kutwa. The B. Ramesh.
Nominated member.
Reasons, right? You don't have any substantive right, and your nomination continues. Pleasure. Okay. That's it.
Not sure what the judge is. Since I've been nominated member.
To say that this thing reasons have to be assigned.
We have to be ego only for student. It cannot be ego arbitrary.
They have not assigned any reason.
I know, produced.
Mr. Subramanya is appearing, right? They have not assigned any. Huh?
Yes. Those are the cases of appointment. Those cases. Cases of appointments, not nomination. Those are the cases of appointments, not nomination.
The distinction is all that is subject to Article 14, right? Everything under the sun. Yeah, all right.
to an extent the security of tenure provided under the provisions of the Act. Section 58 says, on the members of the assembly, term shall be for 2 years. There is built mechanism for I agree that possibly the state government is right so far section 9 subsection independent power. So gives a there is a security of tenure. Even though I am nominated, quickly a nominated position, if the distinction stated upon nominated, not section 28 was section 28 is the provision under which I have been nominated. 28 the Senate consist of the following members, namely was G 6 persons nominated by the state government from amongst eminent executives of whom one is a one a woman, one is a two others. So in this case, one is a religious minority. There is a judgment of a judgment of this honorable court which will squarely find the coverage. The distinguishing feature is section 38 in my respect. Same as otherwise. The term of the office of the members, other than the ex-officio members of the academic and the shall be 3 years. There is a tenure is fixed. The wording of the section also says it's mandatory. First, also says that it is otherwise. Then section 39 is the provision which I think 39 subsection. Key member nominated to any of the authorities under this shall hold office during the pleasure of the nominating authority. Again, nominated to the authority will be liable to be removed. Not a misbehavior, misconduct. In a nutshell, my summary would be this. The teeth of these provisions where a tenure is fixed and under subsection P, when there is a provision to remove it, that is vested in none other than the chancellor. Under section 12 is the governor of the state. Therefore, the legislature contemplated a particular security of tenure. And even though my nomination is the government, it would be subject to my these provisions which provide me a certain security of tenure. Therefore, the doctrine of pleasure would have to be exercised in a manner. Also, consistent with the judgment which I had record. I'll just read one paragraph of that. Yes, my lord, once again must submit that is in case of an appointment, which is why the learned single judge said that division said judgment would not apply. I would submit that it would not make that much of a difference as in the case of a simple nomination. In view of the provision section 30. Only the first judgment.
We think we have also dealt with this issue. Right?
But I guess also.
Yeah, probably it's an independent, like power to nominate or pay nomination, right?
Before that, your lordship,
Yes.
There's some distinguishing. But this pages from never onwards, not taking a lot through all.
Yes.
Page 19. Provisions. This is of course under the context. The context of the Rajiv Gandhi. If I may read paragraph 10 on section 31. Paragraph 10. In 31 of the Act provides Senate council shall be read same every 3 years. Members of the authority shall, except in the case of
It does not prescribe for a tenure.
Next year. Thus, section 31 does not nominated member to select.
You mean to say that once a listing member is nominated to this, can only be removed under 39(3) and
I would not-
government as
I would not go that. I would not. But while exercising.
like that general clauses would apply.
Yes, of course. So I would submit this. While exercising the doctrine of position, and the doctrine of position not to revoke their wings and rights. In light of sections 38 and section 39, which I would submit provides a sufficient security of tenure to even nominated members. The onus on the government to exercise is even more heightened, I would say. Let's take a look at one paragraph of judgment in the memo citation we submitted. First judgment.
Like they have a power to recall, right, the nomination.
In fact, I think also submit in this case, state university, there is a power to remove because if my laws are noted in this particular university, even though there is no power to remove, general clause effect is certainly there. Here, of course, admit section 39 specifically states that this is the nature of the nominating. Who is very good. The one distinction feature I would like to highlight is that term fixed, then possibly, my lords, there is a more unbridled power which is the government to exercise. But my lords, in the text of section 38, which says that it shall be clear, when exercising that document, not for document, cannot be invoked in this case. Of course, there must be some good and compelling reason for the law later on this since of any reasons whatsoever, in fact, I submit for the letters, fine noting were produced. But although I was not.
What were produced?
Fine noting.
Okay. Yes.
So, subject to that there were no reasons. But of course, one eventually that a nominated member, there is no question of reasons being assigned. Therefore, distinguish this judgment of BK there. So, therefore, I would submit, if I may just read one paragraph.
Also, like you have represented the government, right?
Must have. I will submit one of that.
On lighter side.
Advantage, I know. Because sometimes we know too much of how to do advantage, but I also know the limitations.
You know how what all is taken into account in the process of nomination, how it is rescinded. You know that.
Which was it works both ways.
Yes.
That's it.
My lord, that I won't take too much time. The memo cited is submitted. First judgment of
Appointment, right? Which paragraph?
Paragraph, sorry, page. Again, I was extracted portion of the time. The summons of what is it's not the government by invoking the doctrine of pleasure must be for good and compelling reasons, and it cannot be at the state will women fancy the state, but it can only be for valid reasons. And the power referable to the doctrine of public. Now, coming back to the present case, one situation, but again, that the proposals contain valid reasons, the government approves the reason. To make the excess lawful, the fine must show application of.
Have the record. Get it, we would like to see at least, I mean, to this extent. But what happens like division bench says no. For good and compelling reasons cannot be at the sweet will, whim, and fancy of the government. It would only be for valid reasons. No, but by saying that we can do it any point of time without reason, nomination. Oh, if there is any justification, you tell us. He has no right to continue as that. But that only one argument that power has to be exercised for good and compelling reasons. So have you justified in your statement of objection or anywhere saying that for whatever reasons, is some semblance of reason or record for public good? Some to produce. So Vikram Puliko, learning senior counsel of the appellant. Learning counsel for number 2. Senior counsel for the appellant submits that under section 38 within 38 of the Karnataka State Universities Act 2000, the nominated members of the syndicate of the university have a fixed tenure of 3 years, and the 3 years, and the doctrine of pleasure can be exercised subject to. Doctrine of pleasure can be exercised for good and compelling reasons and cannot be at the sweet will, whim, and fancy of the state government. Full stop. In support of such submission, reliance has been placed on of division bench in DK Uday Kumar versus State of Karnataka and others. The current additional advocate general has pointed out that the opposite is to pertains to an appointment and is therefore not applicable to the fact situation of the case. Paragraph. Appropriate to direct learned additional advocate. It is directed that learned additional advocate shall produce copy of the records. Order dated 7/4/2020. When will you produce, Mr.? What date? List on. Tell what date. 20th, 21st, whatever. 22nd September 2020. Petition. Will defer the hearing. What protection? Contempt. We list it along with that. Oh. Yes. Mr. You should be sure about that. You should be sure about that. Comes through one. Senior counsel, Mr. Vachal. Captain list for a logos hearing along with contempt petition number 302 of 22. On what date? Thursday, 15th. So we'll list it along with contempt. 15 September, right? Thursday is 15 September. 15/9. On that day, we will have. Yes. Educate. You are caveat. It needs to be heard, right? Notice. Respondent accepts notice on behalf of the other respondent. This is matter which we may formulate. Maybe is entitled to compensation, right? How can quantification of compensation be done in a proceeding under Article 226? How do we like a infraction of supposing for infraction of fundamental? We are forget about we are giving you proposition, but like we can any litigant can invoke the jurisdiction of this court under Article 226 for infraction of a fundamental right, and this court can grant compensation. There are cases in cases, right? But here if this case is particular amount of say 29 lakhs has been computed. Case of injury. So that is we would like you to vote on this issue, right? Here, yes. Notice on behalf. Right, submit. It was entered appearance on caveat. Then issue notice 2 and 3. Oh, notice on behalf of by Mr. SS Mahindra issue. Case respond number 3 is dispensed with. Let 11th October list for hearing.
Payment will be made only after a period of 3 months.
3 months, right? So we don't think that the initial cut. Happy? No, not yet. She will argue first. Based on 10th October, Madam. 10th October, Monday. 10th October 2020. Then say IA 1 of 22. Requirement to file what color photograph dispensed with. Mixture B and Z is dispensed with. IA 1 of 2022 is allowed. Right? File objection on what? File. Oh. So it is listed for admission, it is to be heard, right? Let the petition be listed for hearing after 2 weeks. What in your favor or against you?
Yeah, disputed it.
He disputing. That's why. So if you want to wait, then you can wait. We thought that perhaps if you want to wait, we hear you then at the subject to availability of time. You want to wait? All right, also. Yes.
Advocate has to retire then. If the petitioner wants to argue as a party in person, advocate has to retire.
No, you make up, I mean, the choice. You will have to retire, then we will. Tomorrow? Oh, he has taken you by surprise. All right, we'll hear you tomorrow. Mr. So and so, Mr. Vishwanath Sabrat seeks leave of this court to withdraw. To retire from the case, he is permitted to do so. Office is directed to reflect the name of party in person. Who shall argue the matter? List tomorrow. Tomorrow. Well,
The point is that
Huh.
I wanted to bring it before how the community is going to be exploited by the eighth respondent. Because the eighth respondent is there. Issued a one prospectus. Page number 25 months. 68 is the
what is the penalty prescribed for fine? No, why?
page number 75. Let me see. Why? Okay. Who is going to admit his students?
Which is the guy?
In the first round, he selected one college.
Life penalty.
What? 5 times.
For what?
Yes, the.
Yes.
75 months.
Age. Yes.
Not 100. 93 months.
Right.
93.
Yes.
Now, sir, fee refund policy for total fees paid at format change. In case candidate wishes to cancel his or her fee, he has to surrender this during the surrender period only, which will enable him or her for refund of entire total fees paid at format change. That's the real point is last paragraph. If a candidate whose name is in the final list fails to join or report and continue the study in the allotted college, he or she will forfeit the entire the candidate deprived an opportunity of getting allotted a seat next best the government merited candidate, thereby blocking a seat. It is to that extent I am also right. There continues, and a candidate is also liable to pay a penalty of 5 times of the fees. Next, whatever fees in the first year he paid the 12 lakhs, 5 times the fees he has to pay. And also they are going to retain the marks card, everything. For that, unless the A is there, UGC and AICT is always giving the notification and also they are going to take the action against them. That is unless the A. I have produced page number 37. Particularly refund of fees and non-retention of the original certificate. How is exploitation is going on? Because of so many complaints are going to this UGC and AICT. How they are going to give the circular. This circular annexed A which I have produced. In that, they have only one pro rata basis, page number 39. How much that can rate it? The fees is paid. The percentage. But here it is not that like that. 5 times the fees, whatever you have paid has to be paid, and then you have to come out of it. All right. No student is going to challenge this one.
Parents are not ready because their fear of psychosis is that my son or my daughter will be going to target. This is only the point I am taking before this one. How? I mean, conservative colleges are exploiting the parents' students.
Yes, party. Fine, fine. We are issuing notice. We are issuing notice. Party person submits that. That the guideline print for framed by namely Comet K with framed for admission to 2022-23 for engineering colleges in Karnataka. 14% submits that. 14% submits that the guideline framed by so and so for admission to 2022 engineering colleges insofar as it provides that in case a student fails to join stroke report and continue the study in allotted college, he shall forfeit the entire tuition fee, and in addition shall also be liable to pay a penalty of 5 times the fee. Is contrary to the notification, contrary to clause 4.1.3 of the notification issued by University Grants Commission in view of opposite submission, issue emergent to respond. Yep. Yes, Mr. Potter. Oh, yes. In this petition, yes, is mark the presence in this petition, the petition inter alia seeks a writ of writ of mandamus directing the Deputy Commissioner Belgavi District Belgavi consider the application submitted by the in respect of land bearing survey number dash right under section 95 within bracket 9 of the Karnataka Land Revenue Act. These are 4 cases. So it is not page 14. Just 68 and 69 say. But only 68, right? Oh, we thought that he is appearing in all cases. So, so learned counsel for the parties. So deemed this thing land, it's all mentioned at page 14 prayer clause. Learned counsel for the party jointly submit that the has already been dealt with by a division bench of this court by judgment dated 21st November 2005 but paragraph in view of forces. Belgavi district, Belgavi, the application submitted by the in of Karnataka. Here, 64 within a period of 2 months from the date of receipt of copy of the order passed to the I don't know. You said it's covered, right? This is what
says 2 months.
we said, huh?
2 months time.
2 months. He wants to file a contempt petition against this thing. Why deprive him, right? 3 weeks. Huh? 3 weeks from the date of receipt. Still not satisfied. Oh, we thought we have granted the prayer. 3 weeks we have said, no, what is? Yes. We have followed, right? What are it? What is your prayer, Mr.? We will issue notice. We will issue notice, put him on notice, let him argue. What is it? We are not in a hurry. What? Mr. What? 38. Required 1 week. Deputy Commissioner consider application. What is the prayer in your petition? Read it. And further direct the revenue authority. So that will conversion fee will depend on the decision which they take, right? No, these directions have been issued only to consider, Mr. So if this all you want, like submit the requisite document within 1 week. What is we thought that the petition is for a direction to decide representation. What is it? Directed to consider the application and shall communicate conversion fine amount payable to for conversion. If he says that it is covered by the judgment, still you feel that solved. We will hear you. Don't write. Don't delete it. Third, on the question of admission, issue notice. Notice on behalf of respondents is accepted by learned government advocate. According to us, whatever, I mean, see, he's saying something else. You are saying we need to put him on notice, right? We can't decide like this. Yeah. We passed an order, right? After you said 3 weeks, we did 3 weeks. Now you are saying that you are not satisfied with this order. So then we have recalled it, right? We are wrong in passing such. We will put him on notice. Let him see this. What is it? We will examine this. What A, B, C, D, E are required. The same thing, mister. Don't understand. Merely because we have written it in a different way. No, we have written it. The prayer is to consider the representation. That direction we have issued. You are not satisfied. Don't tell us how to pass an order. Every judge, no, don't tell us that there is no difference in order which we have passed and this thing. We will record this. If you want to make it longer, so we will record this. That you are claiming parity, principles of parity, and this petition is rejected because it is the same reason. The same order. This is also same, mister. Before that, we have recorded his submission that it is covered by this judgment. Dated, you have read it 35133. You have read it by division bench. We have done it within 3 weeks. If you are not satisfied, what can be done? We cannot pass an order to your satisfaction. Don't tell us. You can only argue. Well, fine. If you want to make it a longish sort of an order, you are welcome. Write down, madam. Yes. No. How this thing you have argued, we will decide. In this petition, the petitioner inter alia has prayed for the following release. Prayer clause A and 2. Learned additional government advocate fairly submitted that the controversy involved in covered by a judgment of this court dated 21st of November 2019, passed by a division bench of this court in WP number 35133/2019. Full stop. After hearing the learned counsel for the parties, we had passed the following order. Right, quote whatever earlier dictated. Paragraph. After the order was dictated, learned counsel for the petitioner insisted that the writ petition should be disposed of on same terms and with similar directions as were issued in order dated 16th of January 2022, passed in WP number 11267/2022 on the principles of parity. Paragraph. We have carefully perused the directions issued in aforesaid case. The directions are reproduced below for the facility of reference, right? A, B, C, D, E, quote, full stop. The order passed by us, which has been quoted supra, and the directions issued in WP number directions number 11267 of 2022 are the same, and same but different physiology has been used. Learned counsel for the petitioner cannot insist the court to pass an order exactly by using the same language. Full stop. Therefore, the contention, therefore the submission made is sans substance and is rejected. The petition is disposed of as in terms as already stated. One minute, let me. Yes. Consider the application for Teams conversation sake. Okay. Yes, what is it? Yes. The owner has given Riksha C. 21. Wonderful. Policy. Motion is concerned only by the owner.
So far as the application for permission, that is crushing license, for that you can get a consent from the landlord. But how a consent you are obtained for the purpose of, so it has to be filed by the owner. Owner, he has to approach the court. You cannot approach this court. No. Here, you are not the owner of the property. You are not the owner of the property. How you will maintain a writ
They
petition?
will file an application. We will say that in case owner files the application, they will deal with it in accordance. Learned counsel for the petitioner fairly submits that the petitioner is not the owner of the land in question. Full stop. Application seeking deemed conversion order in respect of land in question, the competent authority be directed to consider the aforesaid application. Who of aforesaid submission direction that in case owner of the land, needless to say that in case delete the aforesaid submission is placed on record. Needless to state that in case the owner of the land in question makes an application seeking conversion of the land 95 with bracket 9 of the Karnataka Land Revenue Act 90 by the competent authority in accordance with. Next. Tape 21. 51. Okay. Don't Mr. Realize, right? So you issued a guarantee to the client that I will get the order in the same terms. It's virtually, you cannot tell us how to get an order. If you are agreed, that's why we have dictated everything tested in SLP. That say that passes such another bench passes such an order. We would like to know. It's the same order. You are not reading it in your anxiety. You are not reading it. The same direction. He has said that it is covered by, you don't realize you haven't seen that judgment. Said that this order should be passed. Everything else original order. Proceedings. Yes. Yes, please. Yes, mister, what is it? Who is the respondent number 8? This is surprising, right? No. This not. What relief you are seeking against Advocate General? Then how has been pleaded in the writ petition? Strange, Mr. What? You have to delete him. Learned counsel for the. So that doesn't mean that supposing if you give an advice to your client, no,
He was a government advocate. Earlier, he was a government advocate.
Supposing no. First delete. I mean, then we will hear you further. But supposing if you give a client, give an opinion to your client, whether Mr. Mahindra can treat you as a respondent, saying that young man to do some work today. With so and so undertake delete the name of respondent number 8 from the cost. When do you want? Tomorrow. Yes, tomorrow. No. Now he will do it. Yeah, but just no question. Going back. See, this our court officer has the habit of keeping all the files there. See, paper on your left. It's that file has not. Mr. Mohan is appearing in those cases. Huh? So, tomorrow, day after, whatever you want. Day after. Just on 14 September.
Government law says yes.
We don't know. That's the another question which you will have to address. How have you got this? This thing is a privileged communication. How we don't know. We have some questions which we will put you when you argue on this. Yes, all right.
Number 8.
None for the petitioner even when the matter is not taken out. Yes, madam, you have the provision with regard to possession. The additional government advocate submits that the issue raised by way of this public interest litigation has already been dealt with by a bench of this court in several decisions. To stop the opposite line below, the opposite statement is placed on record. Accordingly, the petition is none. Sir, you not 5 seconds. So, right.
What is it, Mahendra?
Yes. What license? Have 5. For when battery is taken up in second. Sure. Let office objects be complied with in which rate petition. That you will consider, right? This petition, the petitioners are petitioner is a resident of Kalburgi. The petitioner has filed this petition being aggrieved by illegal construction, by encroachment, by illegal construction stroke encroachment made on the government land. Full stop. It's none for the petitioner even when matter is called in second round, write her name as additional government right. Then say in this petition paragraph. The continuation. The petitioner has made a representation dated 10/3/2021. How to stop, however, it has been. Finally, this petition has been filed. Paragraph, we have prepared the papers. the facts of the case and in the light of prayer made the petition is disposed of with the direction to respondent petition submitted by the petitioner expeditious. On number 3. Which respondent madam? Who will decide?
This.
Yes. Respond. Number 3 shall be deputy commissioner shall be. Everyone. Oh, before. Technical passer. Mr. What happened? Yes. No, when was the order passed? When was the order passed? Order. When was it passed? January. When the limitation expired? Huh? Did it expire? When it expired? So it's a Gomal land. How it can be allotted? Not simple. Somebody may have got it. At least somebody may have got it. Which provision of law empowers you to seek allotment in respect of Gomal land? Which provision? There has to be some provision of law, right? Policy of the government or anything. Otherwise, if every this thing, even a Gomal land is allotted, nothing would be there. Nothing, no merits. And these are the merits of. You see, 15/6/2022 also you did not appear. Not dismiss the appeal. Today also you are doing the same thing, even though it has been passed. What did we tell you? That you should. You are unable to tell even what is the explanation for delay. Why we should not? We should entertain this. Tell us. You seem to be sound. You are ill. What? You are a young man, right? What happened to you? You told the council. You said that council was not well, right? Morning you said that council was not well, that's why it could not be filed. Then we pointed out that the council had already expired. From 19, from 20th September 2022, it is made clear that no adjournment on any grounds. Don't be happy. You should feel you are not even able to tell us why the delay has been caused in filing the appeal. No need to be happy. only to save you, otherwise your senior will frown upon you. That's why we are adjourning. If we could read it in weekend, why you did not read it? And waiting for us to tell. Don't come next date of hearing, don't appear. Yes. Oh, it is passed over. Item 30. Yes. Yeah. Yes, what happened? What is last direction issued, Mr. Reddy? July 15, 20th July. Yes.
And out of 81. Out of 54 from 22. We have filed an objection. It was like 2022. Filed by them. There is an interim order restraining the designated officer.
When was an interim order passed?
Minister R4. 3 times. I'm sorry. 4 days. That's the interim order exception. Matter in block number 4. The restriction in WP number 26970.
26 0. 2015.
It will be not a designated officer in the party.
But that is in respect of which lake? It is in
Very good.
respect of which lake? Belur lake.
Very good.
Very good.
So there is an interim order.
So far as 81 enforcement staff. We have taken steps to go before. Find out. Yeah, they just not have party in the picture. Also, they can steps again. There are fixing that thing. Therefore, stage and all these. There. Yeah, you said you put forward this issue. Sometimes they will not appreciate. That's the lot of this. Okay.
Forms part of the lake, right? It's part of the lake, right? This is admitted to the issue that this road and slum of the lake. Which is the other lake?
Then
What we with regard to another lake is right?
Puttenhalli lake.
Puttenhalli.
Yes, yes.
What happened, Mr. What did you do? Inform these notices were issued. Where is it?
You are directed to file a compliance request. Also directed to
How,
file a
where is
compliance.
your compliance report? Yes. So this thing is like directed to take steps for removal of enforcement and to submit a compliance report. What have you done? Nothing. You already that word. What did you issue notice? Inform means. And where is your compliance? What is the explanation for not submitting a compliance report? 15 July. Huh? Why? No, you are taking it lightly or what? Nothing will happen with right. Huh?
This time wherever you get it.
Huh? No, please tell us what is the explanation. We are serious about it. Not submitting even a compliance report by that last date of some time back it was entered, right? Speak only. Thereafter also. Why? Why? I will place. Where is the notice? Where have you at least tell us? Orally tell us when will the notice was issued. Very clear. We know that. Just making a statement. When the notices was issued and why there is this compliance report. Tell us. They did not submit. Who is the person responsible? Huh? Wait, one by. Huh? No, you have to remain present first. This can't be missed. Casual. Yes. Uh-huh. Yes. Uh-huh. We have plenty of things to do, like to hear the petitioners also. You can join us. Yes, please, please. No. I mean, like, we have to hear them also. This matter will go on. Please. Yes. Yes. So, executive engineer of the PPM. PPMK, right? What? Go again. Slum board. No. Okay. Slum board. You have identified the encroachment. Then I have conducted survey. So in presence of this executive engineer or how many encroachments as per your report? Mahajan, what have you found out? Copiers for this slum board. Historical. Okay. Sketch of which lake? They are not responding. That okay. There is a BPM. BPM document says they have issued a notice. You issued notice to the officers of some clearance board. One. Some board the party is petition. No. Is 31.5. 49. He's appearing. Income is appearing. R4. I'll ask him. 4964 of which year, madam? 21. Yeah. Yeah. So what do you say now?
In a summary, your said some of the in about 45 there are the injunction. However, the injunction order was dated 4 weeks. So the next week was of 10 weeks. However,
Thereafter, they've told no 16.9. $16.9 is fixed, right? $16.9. You are making a statement. So shall we record it? Look like there is a road. Road.
Their own earlier survey.
No, no. We'll have to remove, but we will have to get the slum board also. The council unfortunately is not appearing, so we will have to direct his appearance on the next day. And, what do you say? Road. And where are these officers? They are present, right? They are present, no? So private encroachments to some extent have been removed. So then you have to, is it a fact that this area is encroached by the government itself, by the authorities of the government? That's what petitioners say. Yes. You initially said that, yes. Yes. So what happens? Right. 2nd June. So you have the copy of the order, madam, 2nd June. Encroachment, it's your report. See, you have filed a memo 11th of April 2022. You have admitted 1 acre, 7 guttas is a space utilized for the purpose of link road between Subramanyapura and Uttarahalli. 3 acres, 39 guttas, slum dwellers.
There should be some plan. But there has to be some plan. Otherwise, my God, the lakes will just it will.
What do you suggest? What is the location of the road, madam? The location of the road, how? What is the supposing if this connecting road we ask them not to use it or whatever? What happens if we are asking you what is the alternative? Supposing they say that this is the only connecting road between Subramanyapura and Uttarahalli, what happens then? Find out then. So that was If we, no, so is there any alternative road, how people would use? That's what we want to know. Petitioners are also not aware. Yes, madam. And he appeared today. You find out, Mr. Mohan, you are asked your client to do something. Find out what is. Huh? But you like orally telling them you will have to put the government. No, they should be put to notice, right? Government has to be. You, you say so on affidavit. We're not saying that it's not in record, but they have to be put on notice. Eventually, they will conduct a survey, find out what is it, what is the extent of land and all this. So you should give in so that we can put that material to the government and they know what is it. Like, some other. You know, 70 appeared. Settlement. Yes, yes. He appeared. Direct. Ah. 12.4. What is the have you got the copy of the IA, madam? Please. Action is to take one copy. You can issue directions right away. I don't think they will oppose. Nobody can oppose you. Give it to them. Yes. 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 Okay. Now water level is not exceeded. You have to take action, Mr. Not a filing this thing of filing objections, right? Like 80. Yes. So like 18 June 2019, there was a direction to survey of storm water drains and removal of encroachment on the drains, right? And suppose they have carried out, this city would not have seen unprecedented floods, right? You have to now, yes, madam, you can't possibly, and there's no question of contesting, you have to take steps, right? For removal of encroachment and to submit a report on the next date of hearing.
This is one of the quite often.
Also, we are very, right now, the idea is with regard to removal of encroachment on the drains. So that's. What is that document? What is it? What is it? Huh. 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 We are, right now, we are dealing with this, right? Encroachment on the drains. Mr. Reddy, this encroachment on the drains, you have to remove. Drains, storm water drains and drains, which has, due to which there was a flood-like situation here in some localities. The government, and he has filed, Mr. Mohan has filed one idea, one of it's only, it's a distinct prayer which you have to implement, right? Please go through what is. There is already an order, 18th of June 2019 is an order, page 2 of the application. He has referred to. This encroachment on the drains have to be removed. You file a thing sticker, take action. We are directing both government and BP. What? This connection only. 18 June 2019. Yes, you have the copy. Please give it. Other sheets. Sheets are there. Yes. Page. That's what is quoted. There is already a direction, Mr. Reddy. Yes, madam. Please, sir. What idea 2 of 20? What is it? What is it? 2 of 20. So that 2 or 5 then they will have to implement that. There is no question. All right. No question. We are issuing direction. Yes. 31.5. Yes. Yes. Yes.
And BPIP is not filed. And the concerned executive transfer. And
Find out who's the executive engineer, right? See, nobody is appearing, right? So we are directing, no? We are directing some officer of there is a slum area, no? That they need to, you are saying that it's not notified slum area. So, which officer will appear, Madam of Slum Board? Who should appear and answer? Tell us. Who should appear? Which officer of the Slum Board? If nobody, council is also not appearing, so we will have to get him, right? He will appear. This is the authority of the Slum Board. We are asking you. Yes. Yeah, but with the other officer. Don't know. Right. We'll find out. Yes. April. Yes. Yes. That's why we are directing, right? His appearance. We don't club up like all the mix-up issues. There's no point like, see, we can issue, mix up the issues and issue as many as directions. Nothing will be done. So then we are dealing with at present this thing, removal of encroachments on the lakes, 3 lakes, and this IA which has been filed for encroachment of, now you are, I think. So please, you file an application, whatever you want, like Mr. Mohan has filed, like he has filed an IA for, we are issuing direction. You file and put them on site. Orally on each date of hearing, Mr. You don't come up with new submission. Like, no, last day we remember distinctly, last date of hearing, you argued about migratory birds. Today you are arguing about. So Reddy, all this, he needs to be put to notice. Please, no, that's all right, Mr. What we are trying to tell you is that see that record. You see that record on your left side. You say, huh? No. There's no question of burdening. What we are trying to tell you is that we have to proceed with this matter in a systematic manner and to ensure, see, you will appreciate that after 2014, we have made some progress and he has removed 31 encroachments. He has just now, he has photographed. No. What we are trying to tell you is, Mr. Your concern is genuine. We are not saying, but there is like orally you say something. How can we ask now Mr. Reddy to respond? You are saying Raj Kalwe. Huh? So now it has flooded, right? Your prediction has come true. So this is what you want to hear, that your prediction has come true. What action? To power to do what? That's what we are doing, right? That's what he's doing. And this, since Mr. Deshpande has not complied, therefore his client is directed to remain present. He told fairly that I informed him he didn't comply. So that's why we are asking the government in respect of 3 lakes, we are going ahead. And since it involves a slum also, so we want to know whether that slum is a notified slum, what should be done, how to this thing. Then you don't know what is the petitioners are not all also not able to tell us, nor nobody has told us that what happens if these routes are closed, these roads are closed, supposing. What happens? Is there any alternative road? All these things have to be considered, right? Government has not considered the impact of all these this thing. So she is also praying for time. We are granting them time, directing appearance of Kambo, and this thing next date we will find out what has happened on 16/9 to his application for vacation of stay. You have filed an application seeking vacation of stay. So that's what I said, that you should file an application. Not filed, then it should be filed. Yes. So we will deal with these issues, Mr. Then not written submission, you put them on notice. Right? Written submission, we will go through. What happens to see these people are implementing agencies. So you have to put them on notice of before each date of hearing what issues you are going to raise so that they can respond. See, this is a public interest litigation, right? Nobody is opposing. These people are not opposing the prayer made by petitioner. Together, we have to find out a solution. So what we are just telling you, they don't know that today you are going to speak about Raj Khalwe. They are not saying that you have not this thing, but that report somewhere must be there in that record, right? Whatever your return submission. Put them to notice at least that I am going to address the court on Raj Khalwe today, or wildlife, or whatever, migratory birds, whatever. So that they are ready, so that they get a time to respond to your this thing, suggestions. That's all we are saying. Otherwise, you will say right now at 4:45, in any case, we will have to grant them time. Let us effectively, we want to monitor this removal of encroachment on these 3 lakes. We want to find out what this about this big slums there and what happens to the roads. I will like it to be uploaded. Immediately it will be available. And your application is allowed. They have to remove. That's it. So we'll pass an order. Yes. Yes.
Hearing.
Yes. 5th October, Monday, or what, 6th October?
It's a case.
Oh, 11th or 12th? Ah, 12th October. 12th October. They will have to appear. Yes. So in respect of other, one lake only, they've partially taken action, right? Huh? And what about the other lake? All right. Busy, yes. All right, yes. All right. Yes, Mr. Ah. So I told you, we have told you this thing, but you said that you want to take chance. Some sort of, which case 65. If time the matter. 20th September. Still, all the cases will be repeated tomorrow. Why are you seeking them all the whatever pass? Everything comes up tomorrow. Which case 773 481 get the record. Yes. It will be repeated tomorrow. We'll get the records. Yes. Get the record. Yes. 9841.
The book is appearing maybe different, therefore it has to
Oh,
notify.
it has to be notified.
And call tomorrow along with.
Yes. Have to pass. Please. WP number 841 bar 20. 9481. 94.
The WP. Corrected.
Corrected. You are appearing in that case.
The writ petition or writ appeal?
How it comes up. Yes. Yes. Tomorrow it will be. Tomorrow. These late matters won't be there, so we expect that it would reach tomorrow. But it's freedom from mask is very good. Today, we have tried. My brother was without mask, so he was comfortable. So I also tried it today. Really, it's good. Freedom from mask. petition.
ನೀರು ಜಾಸ್ತಿ